We will hear from Ecojustice. So we have two lawyers with us, Danielle Gallant and Reed Gomes. And we also have with us Alex Neufeld, who is a 29-year-old climate justice advocate and entrepreneur from Ottawa, Ontario, a volunteer with Citizens Climate Lobby Canada since October 2017. And she is one of the 7 youth plaintiffs in the landmark Mathur et al. Versus His Majesty in Right of Ontario case. And so with that, I will give it over to Ecojustice.
All right, folks. Just was curious, quick show of hands, who was already aware of this case before today? Okay, I see. We're in good company. So we're here to talk about what we like to call Generation Climate Action, the Mathur et al. Versus Ontario case. And just briefly, Reed and I are lawyers at Ecojustice, and we use the power of the law to defend nature, combat climate change, and fight for a healthy environment for all. And when I say we use the power of the law, that includes through litigation, which is what I'm going to be talking about today, but also law reform and strategic communications. So everyone in this room knows it's obviously broader than litigation, but litigation has really become a key tool for climate action, and I hope I will convince you of that at the end of this. All right, so I want to start by situating this case in the global context. Closer to the mic, thank you, Sophia. So none of this will be news to you all, but obviously in 2015, we had 195 governments across the world adopting the Paris Agreement, in which those governments agreed to hold the increase in global warming to 2 degrees above pre-industrial levels, with best efforts to pursue efforts to limit to 1.5. At the same time, and subsequently in 2018, we had the world's leading scientists in the Intergovernmental Panel on Climate Change reports, the IPCC reports, emphasizing that we really must keep global warming to 1.5 degrees to limit the worst impacts of climate change. And we also know from that report and from those scientists that keeping global warming to 1.5 degrees required that governments across the world reduce their emissions by almost half by 2030. One second. All right, so, and at the same time, third piece of the puzzle is that we had the rise of the youth climate movement. I'm not saying this was the beginning of the movement. Youth have been leading this for a while, but we really saw an upswing in youth interest, because despite these clear calls for action, both politically and scientifically, governments were not stepping up to the plate to address climate change. And so youth, really got into this fight to secure their right to a stable climate future. And we also had movements within that, such as the Fridays for Future movement, where young people did not go to school in order to protest this in solidarity with teenager Greta Thunberg from Sweden. So we have these 3 main pieces coming together at the same time. And parallel, we had in the Netherlands the first legal decision in the world to hold a government accountable for a climate target. And so this precedent opened up a question: could this type of case happen in other parts of the world where governments were similarly failing to have the appropriate climate action in order to avoid this dangerous climate future? And so in the midst of all of this, in 2018, the government of Ontario decided to repeal the previous climate targets that it had for 2020, 2030, and 2050, and then replace those targets with one much weakened target for 2030, which first of all represented a 200 megaton increase in emissions, but was also aligned with climate change as much as 3 to 5 degrees when you considered aspects of fairness, as they do internationally in our treaties. And so, sorry, wrong button. Thankfully, in Canada, we have a safeguard against this type of thing, we have the Canadian Charter of Rights and Freedoms, which is part of our Constitution. And so using that key tool, sorry, folks, I think this is the right one. Yeah, you've seen the charter, you know what it is, so we'll just go forward on that basis. And so this case challenges that decision that Ontario took to reduce its climate ambition at this key part of climate action. And so legally, the case challenges this target as being unconstitutional because it violates constitutional rights to life and security under Section 7 of the Charter, as well as the right to equality for our youth and our future generations who will have to live during a time when climate change becomes worse and its impacts also become worse. And we know, for instance, that the mental and physical impacts, as well as the increased risk of mortality from climate events, will become worse and worse, especially if we get into a climate future like the one that Ontario's target is aligned with. Sorry. As I said, we know that our young people and our future generations will be disproportionately impacted, also because the physical and mental health impacts will be felt more by our young people just due to physiological differences. And we know that Indigenous youth in particular will face increased disproportionate impacts as well. Sorry, there seems to be a lag. All right, so the legal remedies sought in this case, great, we're going to address that. First of all, a declaration that the target itself is unconstitutional because it violates those charter rights, and also an order that Ontario has to set a new science-based target that is in line with its fair share of global GHG emissions. However, as I was mentioning at the start, there are also broader goals to bringing this type of case, which include also, educating the public about what their governments are doing and the fact that they have these fundamental rights protected in our Constitution, and also to elevate youth voices who, as I've mentioned, have been really front and center pushing for climate action because it is them and generations to come who will bear the brunt of these impacts. I don't know where my clicker has gone, but if you could please progress. All right. And so this case really made legal history in Canada by being the first case of its kind relying on, thank you, charter protected rights to proceed to a full hearing. And that might seem like kind of a basic achievement, but it was essentially the first of its kind. There were several others that unfortunately had gotten rejected at this stage. And so we were really in uncharted territories, forgive the pun. And so in 2020, I think I lost visual, but I'll keep going. So this case became the first one to proceed. And that meant also that courts were, for the first time in Canada, having to look at the evidence of climate harms and were asked the question, does this violate our fundamental rights? We also, then we proceeded to a full hearing of the merits where this case continued to make legal history by confirming that this type of case is justiciable. And what I mean by that is that it has a sufficient legal component for courts to be able to weigh in on. And again, this seems like a basic issue, but courts have had difficulty accepting this because at times they viewed climate change action as too political a question. So this is a key hurdle that this case was able to cross. We also, the court recognized that Ontario's target falls severely short of the scientific consensus on what the required climate action is. And so it was the first time that a court went and held a government to that requirement in Canada. And the court accepted that by doing so, Ontario was increasing the risk of harm and death to Ontarians, engaging their Section 7 rights. Unfortunately, at this point in the case, it was dismissed because of an issue that's called positive rights versus negative rights. And so negative rights is when the government acts in a way that harms you, whereas positive rights is where government has failed to act. And unfortunately, at this stage, the court found that, in fact, the youth were challenging Ontario's failure to act. However, thankfully, we were able to appeal that decision, and the Court of Appeal of Ontario was able to find that this is not a positive rights case because Ontario has acted. And so once Ontario has acted in setting a target and in taking decisions pursuant to that target, they have to do so in a way that does not violate our charter protected rights. And so, thank you. No worries. So I won't go into detail on this, but I just wanted to put that up there to show the long road that it's been in this case from the outset in 2019 until now. And so the results of what happened at the Court of Appeal is that we're going back to the first level of court. And so we are rehearing these issues. However, heard a great reaction. However, a lot of the key victories that we made that first time will stay with us. And so we've already established that this is a legal issue and that the government, in having an inadequate target, is causally linked to the harms to Ontarians. So thankfully, a lot of those hurdles have already been met. And so it does mean that now we focus on very specific issues of whether, in fact, that this action violates our charter protected rights. And so it is not a complete rehearing of the issues, but rather on very specific parts of that. We'll see when it decides. All right, and all of that I wanted to say needs to be contextualized with the fact that this is a youth-led case. And so we have our applicants from 2019 until now, and they've been a central part of this case. And in fact, they're the reason why they're able to advocate for both youth and future generations. So I just wanted to take a moment to thank them for leading this. It's been a difficult fight. Our youngest client was 12 at the time that we launched this case. And so that's not everything that an average 12-year-old does, is go and sue their government. And so, throughout this case, I know my fellow colleagues at Ecojustice and everyone who's been interested in this case are really inspired by the bravery that these 7 young people have had, and the fact that they are still in this fight. How many years now? 6 years onwards. And so it is a long-term fight, but they've remained determined to see that fight until the end. And I know and I will be giving the mic over to Alex in just a second so we can hear, about her experience as one of the youth applicants on this case. I did want to mention also something that is key, which is the fact that these young people their climate advocacy did not start with this case. They were already leaders in their respective communities, and they continue to fight for climate action, not only in this case, but also in other ways. And so I did want to recognize their contribution, not only to this case, but to the broader movement. And we know that it takes all different ways to push for climate action. And so with that, I will pass the mic to Alex to ask a few questions. So I guess the first is, what has been your experience of being part of this case? What does it feel like to be a youth applicant suing your government?
Wow, great question. Does this work? Do I have to turn it on? Le micro. Ah, ça marche. OK. Premièrement, je suis ravie d'être ici parmi vous aujourd'hui. I'm so happy to be here with you guys today. I've taken a little bit of a step back, and I'll tell you why in a second, from CCL stuff, but it really is a really electrifying feeling being in a room with all of you passionate climate advocates. So I'm so thrilled to be here, and thank you all for being here. Sure. Yeah. Okay. Yeah, exactly. We don't need to clap. You're right, Jen. So what has my experience been like so far? It's been a really gratifying and life-changing experience for sure, not without its challenges. But one thing that's been eye-opening for me is seeing how the Canadian legal system perceives climate change and perceives our rights in the context of climate change, and how we are in some senses kind of fighting an uphill battle to change those perceptions. The fact that for so long climate change was not necessarily considered an issue that could be looked at by the courts because it was seen as kind of this exclusive jurisdiction of the political realm and of politicians who are failing at doing what needs to be done to protect future generations is wild. It's wild that our case is the reason that that's not the case anymore, that it is seen as a justiciable issue. And then also the positive versus negative rights thing, which I'm not going to go into too much because I am not a lawyer and would probably butcher it. But the idea that basically the way I see it, what we're trying to flip on its head is the idea that any action is good enough. And it's not, right? Like, we see that by setting this target, what the Ontario government is actually doing is allowing and authorizing all these other emissions to be emitted. And that's what we're taking issue with. It's not that, oh, they have a target, at least it's better than nothing. No, this target is actually allowing all these other emissions and all this harm that comes from it. And trying to get the legal system to see and understand that has been a challenge that I think our lawyers have handled marvelously, and that we're seeing is starting to kind of unravel. So it's been, a really interesting experience seeing how our legal system functions and the real challenges that we're up against, despite, I think, so many of us being so proud of this charter that we have and that it, guarantees our basic rights and stuff like that. Well, unfortunately, you have to go out and fight for them in some cases. So that's what we're doing and what we're going to continue to do.
I'm going to see. Oh, great. It works. Okay. I won't get up again. Thanks, Alex. And you may have touched upon this a little bit in your answer, but is being involved with this case, was it what you expected, or if something surprised you along the way?
I guess what did I expect going into suing the government? I had no idea what to expect. So I suppose everything is a surprise in that sense. But yeah, just the fact that we have made history so far already, and we haven't even gotten kind of the big win that we're hoping for. Like, obviously, I don't know if I'm speaking for everybody here or just myself when I think a big win would be like, getting a precedent from the Supreme Court saying that we have a right to a safe climate and the Ontario government has violated our constitutional rights. That would be the big win. That's still a long way off, and we don't know what the outcome will be, if that will ever happen. But the fact that we have gotten these wins already, like the justiciability issue, and the fact that the Ontario Court of Appeal did rule favorably. It was a bit of a surprise ruling. I think we were all kind of surprised. We were kind of like either yes or no, and they were like, maybe let's go back down and try it again and see. And so we were like, okay, but that was a win in and of itself, because the courts have never considered climate change in the way they've been forced to consider it in this case. The lower court said it was a positive rights case. The Court of Appeal was like, actually, no, we don't think so. So the fact that we've made history in those ways, we're in legal textbooks already, which I know because I have friends in law school, but so that was kind of feel a little bit law school famous. But yeah, I think that's a surprise that like even without getting that big win, we've already come so far.
Great, thank you. Great, and this was on the PowerPoint. I may have forgotten to say it, but we know the date of our next hearing. It is December 1st and 2nd, so it is coming up. There's a few months, but we'll be in front of the court again soon. And so, Alex, how are you feeling about going back to the Superior Court?
Mixed feelings for sure. On the one hand, we keep talking about how climate change is an emergency. So why is it taking so long for us to work through the legal system in this case? It's, understandably, I think, frustrating for most of us to be feeling that way. On the other hand, the Ontario Court of Appeal did breathe new life into our case and has, ruled positively in our favor. So I think maybe I'm only speaking for myself here, but I feel optimistic about how it's going to go when we do go back. So I'm interested to see how that goes. And on a more personal note, I am 20 weeks pregnant. So the fact that, yeah, thank you. Ah. So yeah, obviously it holds, thinking about future generations like holds new weight for me now. So yeah, thanks.
Yeah.
Oh, I love you too.
Yeah, the next generation of climate activists
Yeah,
on the
it's
way.
thinking.
Yeah. And I'm going to sneak in just a final question that I didn't include in this PowerPoint, but what would you tell a 23-year-old Alex, you know, who is just launching and starting this case? What would you tell her now?
Wow, yeah, what would I tell her? First of all, strap in. It's going to take a long time. You're going to literally be a parent before this is over. But also, I think at the time I maybe had some reservations. Like I knew I wanted to be involved in the case, but you know, I also had a business at the time, and and job stuff. I was working for the federal public service as well at the time, and that is a whole thing. Lots of conversations with values and ethics, and it's kind of like, is this really a good idea? Where's this going to go? But unreservedly, I would tell my past self, like, yeah, just do it. You're going to have a great experience. You're in good hands with Ecojustice, the most talented legal team and comms team that you could ask for. Yeah, so I'd say go for it.
Awesome. Well, I'm glad it was that and not don't do it.
Yeah,
That would have been awkward. All right. On that note, I'm going to metaphorically hand my colleague Reed the mic.
Yes.
See how it's going. Okay, so back to the heavy text lawyer slides. I'll try and parse this all out for you. Classic way for us to show information. We're going to this rehearing in December, and I just wanted to reflect a bit on the moment we're in now, both what we get to go back and argue, a very refined set of things, and Danielle got into this a bit, is that the main things to argue are on Section 7. In the first go around, 2 years ago, the judge did find there are deprivations. The rights of life and security of the person are being deprived of youth and future generations in Ontario. But the real sticking point was, do those deprivations violate principles of fundamental justice? And this is all very technical pieces under Section 7, but that's really where the argument's going to go. So, we had our pitch put forward a couple years ago. What's changed, and what things can we look to reinvigorate this argument and see that we're hopeful that there's a good path forward for the court to make a good ruling on that and a few other issues? Well, I think, yes, this case is taking place in the Ontario system within Canada, and that's really the legal system we're operating in. But around the world, these cases are advancing all the way, including to the top courts like the International Court of Justice. And so you might have heard this summer an advisory opinion came out from that court. Now, to be clear, this isn't some like overarching court that's going to tell our courts what's what and have binding precedents that they have to follow. But this court is very influential and speaks on behalf of human rights issues in many ways, in many influential ways for everyone around the world. And this advisory opinion decided some really key issues to help courts all around the world, I think, understand the task that they're up against. They have to decide what are the obligations of states or provinces like Ontario and Canada under international law that influences their domestic laws for the protection of the environment and present and future generations from GHG emissions. So very topical in our case, obviously. And then what are the legal consequences of failing those actions? So this advisory opinion provides a roadmap that, if they wish to take it up, is very helpful for judges grappling with these questions. So I think it's important to recognize this decision for that. Oh, go back. So some notable passages that I think should be really influential for anybody advocating on this issue when looking at this decision is that it sees as a legal issue that targets that are made must be capable of making an adequate contribution to the achievement of the temperature goal to hold the increase in the global average temperature to below 1.5 degrees. So as a legal fact, a real target, if you're talking about a target, it has to be that. They also say that a clean and healthy and sustainable environment, this thing that we all hope for, it's not just a concept, it's the underpinning of the precondition of the enjoyment of many human rights, like the right to life. And we think, well, doesn't that help us? We do have a right to life in the Charter. And if you don't have this underpinning of the rights of a sustainable environment, how is that right going to mean anything? So I think this is really interesting to think about in our charter context. And then finally, the point that a failure of a state to take appropriate action to protect the climate system from GHG emissions may constitute an internationally wrongful act. Now, this is at international law, not something that's applied domestically. But to know that if someone acting in the international legal sphere may be committing a wrongful act, essentially a criminal act, to know what this court thinks of that kind of action, such as a really low target or endorsing and subsidizing fossil fuels and all these actions that governments take. I think it's just a really important turning point to understand how this top court sees those actions. Now, how are we going to deal with this in Canada? We can't pretend to say exactly how the Ontario courts will think of it when it's brought before them, but we see from the federal court already some important grappling with this issue. Just last month at the federal court, unfortunately, one of the cases moving forward was struck down on a motion to strike again, the Lemigan case that went alongside the LaRose case in federal court. So it has to go back and reconsider its arguments. But the court made some really great comments about how important the ICJ's opinion is in the very context that we're dealing with. So they said when you're challenging under Section 7 that environmental harms arising from Canada's actions and emissions amount to an infringement of the right to life, liberty, security of the person, the courts in Canada, federal court, any court really, can use the ICJ's reasoning to inform its interpretation of the extent of climate protection guaranteed by the Charter, and the principles of fundamental justice at issue must be considered in the light of international norms which they reflect. So already we can see a court saying, yeah, I'm not bound by the ICJ, but it matters. It matters what this court is saying because it reflects an issue in front of every single person, every single court around the world. And I think that speaks a lot that we're already seeing that kind of language. So we hope, of course, that for further decisions will recognize this as well. So that hearing on December 1st and 2nd will focus on that very issue, whether those deprivations are out of line with principles of fundamental justice, and also whether there were Section 15 equality violations. So those are the key points that we're going back to get a final determination, we hope, on this time around. Now, how long will it take to know the next steps, you might wonder? Well, last time I think it took about 6 months to get a decision at this level of court. So a rough estimate, sometime in 2026, really, really precise, I know. But you can expect it within that 2026 year. And then, as we've already shown, the legal system is not the perfect system for acting quick and precise and decisive change. Judges and lawyers, what they are there to advocate for is, these laws and decisions that the political heads make. Are there any ways that they can be tailored and told to go back to the drawing board and do the right thing? But you're not going to have courts rewrite policy. At the end of the day, we need to have an all across the board approach. So yes, supporting this work through supporting the cases like this is also always very important. But at the same time, I think, as you're all here to do this week, making sure that you combine any support you give for these kind of cases as they chug along in the system of justice that we do have to get that final legal answer. You can go and advocate both at MP offices, wherever you are on the street, for faster change, because ultimately, if they just change the target tomorrow, this would all be over, right? But they need to be convinced of that. And if they aren't going to be convinced by you, we hope that this legal point will make sure that they can't get away with it for too long. So that's, I think, about the gist of it on our formal presentation, but we can take, I think there's a questions page. In any case, we can take questions now if anybody has any from the crowd.
Okay, I have not been told no, so I will go ahead and. Okay. Oh, okay. We have 5 minutes. All right. Okay. So first question: could a youth-led challenge like this be successful in another province, such as Alberta? This was asked from a member of our Alberta delegation.
I mean, I think the great thing about a case like this, because it's based on the the Canadian Charter applies to all governments in Canada. So while this case is holding Ontario accountable and the decision that's being made is not going to be applicable to other provinces, it will set a really key legal precedent that can then be used in those other jurisdictions. So hopefully, yes. and hopefully sooner than later. Nationally as well, yeah, also on the federal level. And there are several cases that are currently challenging the federal government, where some of them unfortunately have been dismissed, but another one is making its way hopefully to a full hearing soon.
All right. So this next question must have some urgency because there are 3 question marks. All right. So would ending up at the Supreme Court be preferable because of national implications?
I think so. Again, yes, in the sense that when the Supreme Court makes these types of findings, judges in lower courts in different jurisdictions, give more weight to those decisions. And I'll say one of the key points in our victory, funnily enough, was some of the things decided in the Greenhouse Gas Pollution Pricing Act reference, which did go all the way to the Supreme Court and was very helpful in that the Supreme Court already accepted some of the key facts, where when we first launched this case, we didn't quite know what courts would, where they would start. And so we started from the very beginning and, moved our way through the complexities of climate science. But the Supreme Court of Canada had already made so many of these great findings, so it was so helpful to us that we didn't have to argue that climate change is happening and that these impacts are happening and they're getting worse. So definitely getting up to the Supreme Court level would give us a chance to set a precedent that is even more important and applicable. So I'd say yes.
And I'll just add, this case, of course, it went to the Ontario Court of Appeal, which is already a very helpful point. It's not as authoritative as the Supreme Court. But on any provincial level court or the federal court, it's already an influential decision to guide how those judges might look to get through the strategy and thinking through cases they're presented with. And of course, this case, Ontario also tried to appeal it to the Supreme Court. They had to seek leave. They tried to say that it was all about positive rights. It's not what Ontario's doing. And the Supreme Court didn't say anything about that. They never do when they reject cases. But the fact that they didn't take it up means they didn't think it was the kind of live issue that they wanted to contest. So essentially Ontario's decision, or the Ontario Court of Appeal decision, stands well. So on those sort of half steps that the case has already made big strides on, those are well set in stone in many regards. And so, but yes, for a full resolution of both the charter rights questions and then how the court can give a remedy, ask the government to do something proper afterwards, that's what's to be decided in the December hearing. And I mean, if Ontario dropped the case, I guess it would never go up to the Supreme Court. But if they push on, then you would expect it would get there if we get those victories.
Wonderful. So another question, what are the possible outcomes for the December session?
Yeah, so I mean, I think the 2 things I was mentioning that we're seeking in this case are that the court declare Ontario's target to be unconstitutional because it violates one or both of the Section 7 rights to life and security or equality, and then also that the court order Ontario to set a new climate science-based target. It may be that even if we win, we only get part of that. The question of what courts can do once that violation has been determined is not something that Canadian courts have decided on at all yet. And so we're hoping that we would be able to achieve both, but in charter cases, declaration of unconstitutionality is often what courts do, essentially tell governments off for violating their people's rights. So I think even that would be a big win legally, even if it maybe doesn't seem like it has many practical implications in the legal world. That will then cement the fact that climate litigation is a key tool to push for climate action. I'm already convinced of that, but that's my job, so it makes sense. But I think it'll just make it even clearer that, going to court can have those types of implications practically as well.
Wonderful. And perhaps we'll do one last question. I like the way this one is written too. It looks like the asker started to write even if, but then crossed it out and wrote with emphasis once. So once this case is won, How do we ensure the government does set and meet the appropriate targets?
Yeah.
Sue them again. Yeah.
That's right. Like, I think this shows the importance of an all across the board approach, right? You can go to court. The standard way is to tell a government that what they're doing is violating your rights, and that's exactly what the endeavor here is. The next push is to say you have to do the right thing, and that's a difficulty in a courtroom because courts like to allow, give deference to the government to create their plans and put in action sort of the way that they want to get to a point that's not violating principles when they're acting, not violating your charter rights. Now, we heard from the Federal Court of Appeal that even though Canada doesn't see its charter as a positive obligation, an automatic baseline of a standard of living and a standard of the environment and all these things that allow you to enjoy those rights, maybe climate change is going to test those limits. So that could be that next question of, well, we've never had a positive right to life. We've only used it when governments have acted in a way that's clearly hurting us. But that question is out there of, okay, you have to set a target now. Is there that positive obligation to meet it? These could be questions to be asked in courtrooms, but they're also questions to be asked in civil society and in lobbying and saying, look at this decision. You're in the wrong. A court said so, and work with me to plan the action. So there's multiple ways we can get there to make sure that they meet those targets in courtroom or otherwise. But it'll be a great first step to say that they have to set a target that can actually create a safe future if they're setting one at all.
Well, I guess then what we would say to you all is keep up the good work. Let's another round of applause for Ecojustice.